to celebrate Greg Shaffer becoming a Chancellor's Professor of Law at the University of California, Irvine School of Law. When we were building our faculty, I said what we really needed to do was hire faculty members who would be regarded across the country as wow hires. And I meant that quite literally, hiring people and people said, wow, you got that individual, that is really terrific. Well, in recruiting Greg to our faculty, we truly got a wow hire. Greg is one of the leading professors in the United States when it comes to international trade, international law. He received his undergraduate degree from Dartmouth College, a law degree from Stanford Law School. He practiced law for a number of years in Paris, became a law professor at the University of Wisconsin, was a chaired professor at Loyola Chicago, and then was the Melvin Steen Professor of Law at the University of Minnesota Law School before joining our faculty last July 1st. He is the author of 6 books and over 80 articles. He's received many awards on many prestigious national and international committees. One of the things he's doing here is creating our Center on Globalization, Law, and Society. And if you've been to any of our chair lectures, you know one of our traditions is the chair isn't just honorific, though it is certainly that. It comes with a physical chair. And so it is with great pleasure that I get to present this, which says, Gregory Shaffer, Chancellor's Professor of Law, effective April 6th, 2015.
I feel like sitting in my chair, so. So thank you for coming to this, everyone. Thank you, Irwin, for putting together such an unbelievable law school in such a short period of time, which I'm so honored to be part of. No other dean could have done it. And the staff, the professional staff, I'm going to save my thanks for individuals to the very end, but it's incredible staff all the way through to put this through and support us and help us to be what we can be. And so thanks for coming to this talk. You can see from the title the problem with trade agreements and why we need them, the ambiguity of the question, right? And so these are difficult issues. I don't want to simplify them. They're complex issues. We need to know more information about them to know more about them, and we don't. And so I like to start the talk with a question, which is the lead song in the most sold jazz album in the history of time, which is Miles Davis's from Kind of Blue, So What, is the lead song. And so what, you might ask, it's a critical question. And we'll see if this lecture leaves you angry, if it leaves you engaged, or if it leaves you kind of blue. You'll note from the slide the alphabet soup, or another way to put it, the alphabety spaghetti of international trade agreements and organizations. It recalls me of my childhood about tactics my parents used to try to get me to eat things. And the question is, were they good for me? So it recalls the reality of international trade agreements today that resemble a bowl of spaghetti, as there are hundreds of preferential trade agreements, over 300. There are thousands of bilateral investment agreements, over 3,000. All of these have acronyms, and if you put all the acronyms together in a bowl and they float, what do we have? So, what? International trade agreements seem relatively distant for many of us from our everyday lives. They are usually negotiated in secret, and we find out about them afterwards. Their texts are detailed and complex and incredibly legalistic, and it's not like reading Shades of Grey. So that could be another title for my talk. Though a bit less salacious in its content. So what does civil society think? Well, in 1999, civil society in the United States was very engaged. Just in Seattle, there were between 50 to 100,000 protesters, and the protests became violent. How many of you here have heard of TTIP and TPP? Yeah, many. Okay. Well, in Europe, TTIP excites some interest. So here's a photograph in Germany of a protest of 25 to 50,000 protesters in Berlin against TTIP. What about in the United States? Well, here's 19 who stand against TPP, right? So we don't. So it's fascinating, right? Why are these agreements not really caught the imagination of the American public and civil society? Well, my argument is the reverse of what's reflected in these photographs. That is, my argument is that the WTO should be firmly supported and is essential as a multilateral organization that serves as a dynamic forum for negotiation, deliberation, and dispute settlement. That the Transatlantic Trade and Investment Partnership involves relatively equal bargaining partners at relatively equal levels of development and should be supported as an opportunity for building regulatory cooperation to address the challenges that face us and build closer transatlantic ties. And that the Trans-Pacific Partnership, TPP, which involves parties of very unequal bargaining power, raises serious questions, even though there may be strong arguments that it is in the United States' interest. Of course, our government, under the Obama administration, pushed by lobbies, is taking the exact opposite tack. It has been responsible for largely letting the WTO Doha negotiations die, what was called the Doha Development Round, to advance issues of particular importance for developing countries. It has not yet aggressively pushed the Transatlantic Trade and Investment Partnership, and it is prioritizing the Trans-Pacific Partnership as part of its pivot to Asia and its China policy. So what is actually an easy question to answer? Let me give you some examples of why it matters. The WTO agreements, it sure looks like law, right? 30 agreements, 30,000 pages of text, much of that schedules of legal commitments, but precise legal commitments with respect to all goods, all services, from lawyering services to financial services to insurance services all the way down. It has 4 for deliberation. It's estimated that there are over 5,000 meetings in Geneva every year. That's a lot of engagement between countries. Over 160 countries, about to become 161 countries, represents about 97% of global trade and 97% of the global economy, basically the entire global economy. And countries from China to Russia to the United States meet on a daily basis. And it has a dispute settlement system. Do you know how many disputes there have been between China and the United States before the International Court of Justice? 0, right? 0. There's no rule of law dispute, third-party dispute settlement between the United States and other major powers before the International Court of Justice. What about before the WTO? Do you know how many? Just since 2002, not since 1948. Since 2002, there have been 25 disputes between the United States and China. 9 brought by China against the United States, 16 brought by the United States against China. China's been a party to 45 legal disputes before the WTO, before panels and the appellate body. It has an appellate process. China also has been a third party issuing its views on the legal interpretation and 119 additional cases. That's called engagement with multilateral legal texts by what are considered today the main rivals in international relations. The jurisprudence of the WTO has generated 90,000 pages of jurisprudence. There's a lot of case law. WTO trade and GDP, world trade and GDP growth, we see since, 1980, that global wealth has increased almost threefold, and trade has increased over sevenfold. Countries opening up their markets for international trade has helped spur amazing development across the world, especially those that have been engaged, such as India, China, Brazil, the United States, and Europe as well. And so there's real correlation between the shift towards opening up borders for trade and growth. The question then is, what about TTIP and TPP? Well, here's a slide which shows who are the members of the TPP. You see it involves some large economies, the United States and Japan in particular, as well as Korea, as well as Australia, as well as Chile and Peru and South America, as well as Singapore and Malaysia and Vietnam and Brunei. Okay, 11 countries in Asia. Now, what's new with Trans-Pacific Partnership, this particular agreement? Well, one thing is these countries have already signed a lot of agreements with each other. So we already have NAFTA. Canada, US, and Mexico are party to the TPP, but they already have an agreement. And the US has signed agreements with Chile and Peru and Korea and others. And you see other regional agreements and other. So what this text does, is consolidate agreements into a single text for countries that represent over 30% of global GDP and global trade. And if you combine that then with TTIP, which is also over 30%, both contain the United States, but we're getting close to between 45 and 50% of the global economy covered by these two agreements. So consolidating all of these texts, and of course, when you're talking about bilateral texts, we're talking about a lot of them, into one or two texts, we're really creating a lot more coherence. We're also, of course, doing this under a new set of rules. And the question ultimately is, what is the content of those rules? So just to give an example with respect to TTIP, just the amount of trade involved. Between the United States and Europe, every day, $2.7 billion worth of goods comes into the United States from Europe. And 2 billion euros are traded into Europe. In terms of investment, there's $3.7 trillion worth of investment of Europe into the United States, and 2.8 trillion euros of investment of the United States into Europe. Okay, so the question then becomes, these are important agreements. They matter, okay? So what do they contain, and what effects will they have? Well, there's a big business now in terms of projecting what effects they will have. And it depends, what do you measure, how do you know, and whom do you ask? So if you ask the Peterson Institute, which is based in Washington, D.C., it looks terrific, the TPP. U.S. wealth is going to grow over 50 billion. And of course, then if they project, if it then becomes consolidated for all of Asia, the idea is this is a template to which China will then join, and other ASEAN and other countries will join, you have this immense almost a third of $1 trillion benefit. Okay. Now, the U.S. is a big economy, so if you look at this relative to the U.S. economy, it's actually not that much, right? But the slide looks quite impressive in terms of why we should sign this agreement. Well, if you go to an organization more on the left, the Center for Economic and Policy Research, they say, guess who gets all the gains that were in the previous slide? Well, the 1%, right? This is, of course, on wages, right? And of course, it's about the impact not on standard of living, right, per person, because in theory, with this, prices will decrease, goods will become more available, we'll have better goods for lesser prices. But they are suggesting that once more, the 1% will be the ones who benefit from this trade agreement. Now, economists typically respond that, well, if they're net gains, all we need to do is redistribute them, right? The problem is, in this country, in the politics of this country, we don't seem to be too engaged with redistributing them, either through creating basic health care, other social security networks, minimum wage laws, and so forth. But in theory, we could, right? Thomas Piketty and others, James Tobin, economists, who are not opposed to trade, suggest, well, if we only had a global tax, for example, on capital transfers from all of this $1 trillion of investment in trade, and you just had a tiny little global tax, just think how much revenue that could raise for governmental services. Well, the question then is international and domestic politics as well, whether we're willing to do this. So how do we know the content of these agreements? What do they contain? The answer is, we don't know, right? They're all negotiated in secret. We're told that the TTIP's going to have 24 chapters and that and it's going to be thousands of pages, and that the Trans-Pacific Partnership Agreement will have 29 chapters and have thousands of pages. That's a lot of law, but we don't know what it is. Now, we know a little, right? We know a little thanks to, one, WikiLeaks, right? So portions of the TPP, only 3 chapters out of the 29 have been leaked and are available on the network. They're the most controversial chapters. So one is on intellectual property protection, and the idea is being pushed is ever more intellectual property protection. And the other is investor-state dispute settlement. In terms of the ability, providing rights for investors to be able to sue countries for unfair treatment of their investments, including expropriation of their investments. The third is an environmental chapter, which is critiqued for not providing enough, right? But it is an environmental chapter that provides some minimal requirements for environmental protection of all members of the TPP. We also know, I should say, a little bit more about TTIP because unlike the US government, the European Union Commission has actually put its positions on the web, including negotiate text that it would like to see signed. It can't put the negotiated text online because the US has signed a confidentiality agreement with the Europe to prohibit it from doing so. But it has a lot more information in terms of what its negotiating positions are, what text it's proposing, and so forth. Something that would be nice that the Obama administration might consider doing. So what do they provide? Well, this is gathered mainly from the EU website with respect to TTIP, the Transatlantic Partnership. Well, it's going to cover market access for goods. Tariffs still between US and Europe are low, but it's almost 50% of all goods. So those tariffs, the idea, most of them are come down to zero, complete free trade. To give you just 2 examples, in Europe, they charge a 10% tariff on all US cars imported to Europe. The United States charges a 25% tariff on all light trucks, i.e. pickup trucks and minivans, right? And so those will come down. It also will include services, many more services commitments, financial services, insurance services, and so forth, accounting services, legal services. It will also cover government procurement. Government, sometimes critiqued for being too big, it is big. It's about 45% of the size of GDP in the United States and Europe. That means government buys a lot of goods and services. And the core provisions with respect to this is 1, transparency in all government procurement, and 2, non-discrimination. Right? Most government procurement is based on provisions such as the Buy America Act, instructing to buy American, and Europe to buy European, and so forth. Rules of origin. Where do these goods come from that get 0% tariffs? When you have 300 agreements with 300 different rules of origin, it becomes incredibly complex in a world where components come from many different countries to determine what the tariff rate is. And so part of what these agreements do, covering half the global economy, is really simplifying for any business, any trader, determining what tariff rate it has to pay. Part two, in this particular agreement, regulatory cooperation, I find fascinating. And it depends on, the question is, what's it going to say? What Europe would like it to say is that we create processes where regulators actually talk with each other in different fora to try to figure out whether or not they can come up with standard testing, come up with common safety requirements, and so forth. The question will be, do we treat regulation as just a trade barrier that needs to be deregulated, or do we treat this as an opportunity for regulators to engage with each other? Technical barriers to trade, sanitary requirements are just different types of cooperation, different types of rules where particular regulators can engage with each other. There's also in the TIP, the Transatlantic Investment Partnership, chapters for many different sectoral regulation. So for auto regulators to get together to determine what auto standards will apply. For cosmetics, for chemicals, for pharmaceuticals, for medical devices, for all sorts of different products, creating much closer interaction between the regulatory officials that regulate them. In a world of global trade and global competition, having slightly different regulations completely is much more than a 5% tariff. You have to have an entirely different production line. So the idea is to get regulators to try to learn from each other and develop potentially common rules, or if they have different rules, justify the differences to each other. And then finally, some of the most controversial rules, part 3, intellectual property, investor-state dispute settlement. Competition law, which for the Trans-Pacific Partnership really means disciplining state-owned enterprises, not so much within the countries who are part of the Trans-Pacific Partnership, but to create a template in case China someday joins, right? Or to create a template which will become the rule for the negotiation of any other agreements. And then sustainable development issues. There are provisions on the environment, on labor, on adoption of certain ILO International Labor Organization core labor standards, and corporate social responsibility. What's the analog to this? What's the closest analog to these agreements in US lawmaking? Well, we don't actually make that much law in the United States these days, right? The 112th Congress, only 220 bills became a law, and most of these were of minor significance. There were over 6,000 bills in the House of Representatives, over 3,000 in the Senate, and only 220 became a law, right? But notice, 29 chapters affecting vast domains of law regulating all services across the board and so forth. This is a major omnibus law. Right? This is one thing. When this is brought before Congress, if it is, there's going to be major adaptations of legislation. And of course, not only in the United States, but in any other country. So, of course, we don't know what the text is. We won't know what the text is until it's finally presented. And when it is presented to Congress, if this is what the Obama administration is seeking, what is called trade promotion authority, it won't be adopted pursuant to traditional, conventional House and Senate rules. There'll be limited floor debate. There'll be no committee hearings. It'll go straight to the floor. There'll be a timeline where they have to vote yes or no. There'll be no filibusters, right? No Senate filibusters. There'll be no bottlenecking of the legislation. Senators and members of the Congress will have to take a stand. They'll have to vote yes, or they'll have to vote no, and there will be no amendments. Okay? Now, many critique this as anti-democratic. I actually believe it's more democratic. I think the problem is our regular domestic lawmaking process where we can't pass any legislation because of filibusters, because of bottlenecking in committee and so forth. And that we should have members of the House and members of the Senate taking a stand. And the other argument that we have to do this is because every other country with whom we're negotiating has a parliamentary system where the executive will stand for the parliament and they will consult with their party and they'll vote yes, right? We don't have that. And so we can't say, oh, we'll go back and say, well, we'll have to change this and change that. No other country does that in an international treaty. That's the argument for it. And so there will be a vote. And the content will matter. So here's the quandary for me, and I think for all of us. One, we live in a globalized world with markets, incredible global markets and cross-border transactions. And the question, and any country's regulation unilaterally is going to affect others, and that's going to create conflicts. And the question is, can we create organizations and mechanisms where we can talk through these conflicts, create committees, right? Create common rules, and create third-party dispute settlement systems? That seems to be an incredible achievement. If you think of the alternatives, right? And the conflicts, for example, in the law of the sea in the South China Sea, where China could go to war with Japan, with the Philippines, and so forth. And there's no third-party arbitration to determine how to interpret and apply the law of the sea. Seems like this is an area where we have these types of institutions, and we should create global governance institutions. But on the other hand, the potential and also the potential for expanding regulatory cooperation so that we could, in this world, regulators can learn from each other, coordinate with each other, and address common issues. So just to give one example in the WTO, I'll hold off on that, on fisheries and the collapse of fisheries and how potentially some of this could be addressed through trade agreements. But this involves huge quantities of law, more than we pass in any other bill before Congress, and we have no transparency. Okay, so what's wrong? Well, what's often raised first, you see, is intellectual property. Just the intellectual property chapter alone in the TPP is 77 pages of law, right? Very legalistic, right? You need to be able to know intellectual property law and read the fine print. Just to give a couple examples, it expands the term for copyrights from 50 years after an author's death to 70 years. Under TRIPS, it's 50 years. It expands it to 70 years. Now, for the United States, it doesn't involve any change of law. Of course, what it involves is the export of US law to other countries. And the question is, what's the optimal level of copyright protection for them? Right? All economists know it's not a question of ever more intellectual property right. You could have too much, or you could have too little. You have too much, it'll stifle innovation. If you have too little, it won't provide incentives for innovation, but how much? And the position of the United States has just been more and more and more for every other country in the world. It provides patent protection. This is very seemingly technical, right? Dan Burke, if you're here, could explain more of this, but even if such invention does not result in the enhancement of the known efficacy of that product, you can get a patent. Well, that's the law of the United States. You can evergreen and renew your patent if you find, quote, a new use, even if the efficacy doesn't change at all. India has a different interpretation, has denied certain US companies and this involves, I believe, Viagra as well, in terms of new uses discovered, but no enhanced efficacy, as whether or not to grant patents. But there are many, many provisions. There are 77 pages of them, of details. And the question is it optimal? And what sort of discretion for different countries should they have? Should there be one single rule, or should countries have a choice? Investor-state dispute settlement I'll get to in a moment, in the next slide. Capital controls. Well, the United States has been pushing for eliminating capital controls. China, of course, has lots of capital controls. And guess what? During the Asian financial crisis, when money fled all throughout Asia, except for countries that imposed capital controls, such as China and Malaysia, that their economies were destroyed. People were hungry, they starved. And the IMF, thank goodness, they wanted China to retain its capital controls, to have some stability, some financial and monetary stability in Asia. And of course, we've seen what's happened with respect to our latest financial crisis. So why should there not be the ability for countries to have prudential regulation? How much investor protection of investor capital is too much? Development policy space, this again is a question of the United States is removing the ability for developing countries to engage in subsidies of industries in order to try to build up their different capabilities where traditionally to move up the value chain of production. Should that be limited? What's not talked about so much, but which actually concerns me in particular, is the potential undermining of multilateralism. The United States is disengaged from negotiations in the World Trade Organization and put all of its energies in these particular fora. President Obama has said and written that what we're trying to do is write the rules for the 21st century, not China, right? Well, it's not the United States isn't being able to write the rules that it wants in a multilateral fora, so it's trying to write them in a fora where it can. That's what's happening now. That may be fine as long as it doesn't put us in a situation where we have conflicting blocks, divided Asia, a divided world, a contentious world. So investor rights, this is one of the most contentious that you'll see being debated. And there are letters before Congress, and I've received both. There's a new one which is more pro-investor rights. There's one, and Senator Warren has come out very strongly against this. The reasons for these are to have common rules for the protection of investors, such as you can't expropriate an investment. You have to provide non-discrimination. You have to provide basic due process. And you have a third-party decision maker. You don't completely trust the national courts, right? And guess what? That's the reason why we had the federal court system in the United States for diversity, right? Jurisdiction, because we don't trust local courts to be completely neutral and unbiased. So it makes sense. And to just give an example of a recent litigation, a big patent litigation you might have read about between Apple and Samsung with respect to their mobile phones. I don't know if I'm un-American by having a Samsung phone, but given where Apple produces most of its phones, right? It's a question. But guess who won the litigation in Korea? Guess who won the litigation in the first instance in the United States over the exact same patents? Okay. Surprise, right? Samsung wins in Korea, Apple wins in the United States. But then even better, finally, in one claim before the International Trade Commission with respect to patents, Samsung won. But under Section 337 of the U.S. Trade Act, it provides the president with authority to overrule the decision if it affects the nation's welfare. And the Obama administration did, and instructed it to reverse its ruling, right, and decide on behalf of Apple. Okay. That's the reason why, right, you might want to consider having a third-party decision maker, right, for disputes. But then here's the questions concerned, and I'm a critic of investor-state dispute settlement as well. It provides for arbitrators who are paid, just one round of arbitrators. There'll be 3 of them. They're paid by the investor and the state, and they're paid a lot of money, and they do quite well. And they interpret controversial claims that could be controversial in domestic courts, but they're deciding them in what had been an opaque process, which raises real concerns. So if they decide, if they hear a claim that an environmental regulation constitutes a takings, and it's an arbitrator, and it's saying that because you adopt the environmental regulation, you have to pay the investor for their lost profits, that raises justifiably a lot of concerns. But so it would if it was before a US federal court. Eli Lilly had a patent claim denied by a Canadian court, and it's calling that an expropriation and is suing Canada before an investor state arbitration panel for that. And we'll see in the coming next slides, a master of this are tobacco companies. Fair use that we like to use for our materials and our classes, right? Nothing changes in these agreements. In certain special cases, provided that such reproduction does not conflict with a normal exploitation of the work and does not unreasonably prejudice the legitimate interest of the author, you can make a copy. But it's now potentially subject to investor-state dispute settlement, right? So then an arbitrator can decide this, and claims are made that this could undermine U.S. fair use law because it wouldn't be U.S. courts. So tobacco is, I think, it's a scandal how tobacco has benefited from international trade agreements and how it's going to benefit from the TPP. So we know, besides just health, the cost to human health, of individual health, it's estimated to cost the U.S. economy over $300 billion a year in combination of direct medical care and lost productivity. Yet smoking has declined significantly in the U.S. from over 42% in 1961 to around 19% today. And Philip Morris is still doing quite well. Why? Because all of its sales now are international, or a significant amount, growing amount. Note that as tariff rates have gone down, are being negotiated down through free trade agreements, consumption of cigarettes in developing countries is increasing. Now we have a convention, a United Nations Convention of the World Health Organization called the Framework Convention on Tobacco Control, which instructs countries to have packaging which warns smokers of their risks. Now this is a little scary, right? So we don't want to have bad dreams. We'll move on to the next one. But that was Australia, and here's what Uruguay forces you to put on all cigarette packs, to think twice before you buy one. Now, it does leave a little bit of room for your brand name, right? And guess what? They're suing. Philip Morris is suing both before the World Trade Organization, suing Australia and Uruguay, and suing before an investor-state dispute settlement because this is a taking of their trademark. Okay? This is a taking. And they're spending, these investment arbitrations are supposedly costing between $10 to $30 million to defend, which if you think how much a small country like Uruguay has and its sort of anti-smoking mitigation budget, that's a lot of money going to lawyers to litigate this. Okay. It was so much that Uruguay just about capitulated until Michael Bloomberg stepped in and said, here's $50 million to keep you going, right? So now the litigation is between two billionaires, a bunch of billionaires in the United States over tobacco legislation, right, in Uruguay. Philip Morris, with respect to international arbitration, how did it bring international, American company didn't have any international arbitration, a bilateral investment treaty with Australia. So what it did is it looked for a country that did, set up an affiliate to run its Australian operations in that country, and then used that country's bilateral investment treaty to sue Australia for a taking. Right? Before the World Trade Organization, the United States is not suing Australia with respect to this particular, quote, violation of the TRIPS agreement of intellectual property rights. Rather, they've looked around for countries where they could pay for the lawyer's legal fees to bring the case. And they're paying for the legal fees of the Dominican Republic. And British American Tobacco, also the second largest American company, is paying the legal fees for the Ukraine, which actually doesn't sell any cigarettes to Australia, right? And Honduras, right, before the World Trade Organization. So they can just shop for a country, right, to bring this. So good question. Why the second part of my title? Why do we need these things, right? So first, the caveats that I want to express, which is first, I'm not contending that content doesn't matter. Clearly, content, the substance of these agreements matter. Second, for me, multilateral agreements are a lot more important than these bilateral investment agreements and bilateral trade agreements. The TPP and TTIP are a little different because they're bigger. They involve, as I said, almost half of the global economy collectively. But these are the real caveats. There's reasons for international cooperation in the World Trade Organization. We need this. We've gone through a period of time before during the Great Depression and World War I. If you compare what happened in the world during the Great Depression and the reaction of countries of raising trade barriers around the world so that economies became autarkic and everybody suffered, and it raised nationalist tensions and international conflict. And what happened during the Great Recession, where they talked about this in committees in the World Trade Organization in Geneva, it's a huge difference, and we can't take it for granted. And let's also not compare sort of all the horrors of international dispute settlement with the nirvana of domestic courts. So I just taught, one of my students came by after teaching a class, this case, Procopa versus Carnival Cruise Corporation, a scandalous case where US courts have interpreted employment contracts for foreigners working in Carnival cruise ships as, quote, commercial contracts subject to international arbitration, where in the contract that Carnival Cruise writes for all of these employees, they can go off, instead of litigating in the local court in Texas, in Galveston, where the ship leaves, they can go off to London. And there'll be one arbitrator. The arbitrator will be paid by Carnival Cruise. They'll have to pay their own attorney fees. They can conduct no discovery, but they can go to a doctor provided it's Carnival Cruise's doctor. Okay? And that's all upheld as justice by the Fifth Circuit and other US courts. So if that had gone before an international tribunal, I am sure that despite all the problems with international arbitration, that they would have not come up with that interpretation. And if you look at every other domestic court around the world where this has been raised that I've seen, they've never come up with it. Just north of us, Canada said, that's not a commercial contract. Australia, that's not a commercial contract. Right? But US courts think, oh, no, that's commercial. As long as you it says in the contract itself, this is a commercial contract, of course. Law and order are first steps for deciding anything about justice. We have some great philosophers here in the audience today addressing questions about global justice and the global economy. We have to have some sort of basic governance mechanisms, right? That can spur questions of justice. There's been a lot of pressure on the WTO. Just recently, it has issued its first decisions creating, quote, exceptions on moral grounds for domestic regulation that had never been litigated before. And so that puts pressure for amicus briefs, for greater transparency, for taking justice issues into question. It's much more difficult to do when you don't have those governance structures in the first place. And then one of my favorite worldly philosophers, Albert Hirschman, wrote a wonderful book called The Passions and the Interests, in which Hirschman says, what led to economic growth in Europe after the Middle Ages? It's that, well, we started to have pursuit of worldly gain, of material wealth. And that's not necessarily a passion that we're all that proud of, but compared to the killing of apostates, that was a great advance, right? And so we should think about maybe these sort of material interests compared to televised beheadings, right? Or suicide bombings as a form of that. Maybe that's not a bad thing that people should be engaged with instead. So I'm going to stop there, running out of time. But what should we do? Demand enhanced transparency. Don't abandon multilateralism for regional positioning. Build and interlink complementary international institutions into the trade institutions. Reform investor-state arbitration. Link with domestic regulatory institutions so it's truly transnational, two-way flows of norms, that not just simply top-down. Engage with issues of justice, but building from basic forms of governance that provide order. And build legal capacity. Much of my career in this area has been work on building legal capacity in developing countries for their negotiating positions, for defending their rights. Law is not free. It's not, as Anatole France said, in all its majestic equality. It forbids the rich and the poor alike to sleep under bridges, to beg in the streets, and to steal bread. So thank you so much for all of this, and thank you to all the wonderful staff, to my assistant Paulina, to my research assistants Vincent Lay, Lauren Shelby, and Conley, to my new Globalization Law and Society Institute colleagues, and all my university colleagues, and to my students from whom I learned so much.